In case you've missed it, the United States Supreme Court has put forward their opinion on the Dobbs versus Jackson Women's Health Organization case, and that has effectively overturned Roe v. Wade, meaning that it is tossed back to the states and they can determine whether or not to give women the right to have an abortion. There is a ton of nuance here going on with people like Justin Kavanaugh saying that while they have put forward this opinion, he, in his personal opinion, doesn't think that states like, I believe it's Missouri, can try and legislate beyond the bounds of their state lines and say that, hey, you can't go get an abortion in other states either, or you'll get in trouble. And, you know, we'll also look at kind of Alito's originalist interpretation of the Constitution, how that factors into his decisions and maybe some decisions of other people on the court, why they've come to this ruling, why people are dissenting to this ruling, giving you guys a little bit of a vocabulary lesson on things involved with the Supreme Court of the United States. And if you're not an American, maybe this will be helpful to have some conversations with your friends about it, or better understand something that you might not have the prerequisite information to understand. I want to open up with my personal opinions so you have kind of a benchmark of where I'm at before we get into things. And then we'll talk about Obergefell. There are many, many cases in regards to what the Supreme Court may start ruling on given this decision, or things that are related to this decision. And I plan to, over the next few streams, go through that. To make a long story short, though, we kind of got some insight into Clarence Thomas off in his own corner, thinking about things, and he had an interesting interpretation of everything. And then we had oh boy, we have Alito, who is an originalist, which means that he believes in thinking about the Constitution from the perspective of the founding fathers that wrote it, and being really, really strict about expanding definitions and rights from the Constitution. What he says, and what a lot of originalists say, and we'll probably see repeated again and again with different justices on the court today, is that if you are going to be expanding rights beyond what's explicitly stated in the Constitution and its relative amendments, then that needs to be based in tradition and history in the United States. And so if you hear tradition and history, that might give you some indication that people are thinking about things from an originalist context. And if there isn't history and tradition, people that are originalists in their beliefs may not think that we could expand upon the document or think about it in these ways to kind of talk about what's happening in the modern world, or where modern political opinion is at. And so that's their opinion. So in my personal opinion, I believe women should have the right to abortion mediated by interactions with physicians. I am, however, also partial to the argument that states should have the right to make choices about the specifics regarding abortion, and that some kind of legislation around the issue is how it should be solved. That being said, I'm not opposed to federal legislation outlining such a right and reigning in the states. Ultimately, I don't know if the Supreme Court is the place to debate these things, and this should be a legislative issue, though I'd hope that legislation errs on the side of giving the right to abortion. As of recently, I have, however, moved on this and have been more amenable to the idea of SCOTUS defining rights to reign in the states and the legislature. If they do this, they really need to make solid arguments that people can understand, to give footholds and arguments to the average American citizen and representative. Plessy v. Ferguson and other cases have been necessary in doing this, and while it would be preferable to get legislature passed or amendments ratified, that isn't practically viable nowadays, leaving SCOTUS an important player in defining and protecting rights of American citizens. I don't know when life begins, and I'm not super interested in debates regarding this, seeing as it's a very personal and individual belief. I did, however, enjoy the debate between Zen Shapiro and Alex Kirsch on the topic. I think that these philosophical conversations are trumped by the opinions of physicians and individual patients who can make their own calls on life and abortion and act according to them. It shouldn't necessarily be debated, legislated, or determined by individuals outside of the by individuals outside of the individual, though as purely a matter of law, it would seem the states and legislature have this ability, barring what SCOTUS's opinion on it is. When it comes to a topic like this one, I'd like to see more people divorce this from the realm of philosophy and talk about things at a legislative or judicial level, given the context of the moment surrounding SCOTUS and their decision. So I'll go through some vocabulary, but we'll probably come back up on this when we're talking about Obergefell. The federal courts are divided into districts, which are the lower courts, and those are the ones that hold trials, and circuits, which are only appellate, and they don't do any trials. So when you have a trial about something in your state or something that is about the federal government or rights or things like that, you'll first have it in a district court, which will make a decision on that. And then once you appeal that decision, or if you appeal that decision, it'll move up to the circuit court. So if you ever hear us talking about district court decisions, those are the ones that hold the original trial, and then circuit courts are the ones that handle appeals for those trials. Furthermore, incorporation is another important thing that we'll talk about with Obergefell. Incorporation is applying portions of the Bill of Rights to the states. So when we're talking about the Bill of Rights and we're talking about the Constitution and the rights that are, afforded to citizens in there, that's meant to apply to the federal government. And when you apply those rights or those restrictions or whatever to the states or to state governments, then that's called incorporating them. And so when we talk about incorporation, that's what we'll be discussing. Lastly, we want to make a distinction between briefs and opinions because those can often get mixed up by myself and other people. So briefs are submitted by those involved in the case and outside of it. So when you submit to the court your arguments for why you believe a case should go one way or the other, you're submitting a brief. People outside of the court case, in the case of the Supreme Court, can also submit friend to the court briefs that are going to give their arguments about why it should go one way or the other. So for instance, if we're talking about abortion, you might have the two people involved in the case or the two parties involved in the case submitting briefs, but then you may also have friend to the court briefs that are sent by organizations that know something about it. So in the case of abortion, maybe they'll talk about some statistics or things like that because they're an organization that works with patients who undergo abortion or organizations that perform abortions, and they may have some opinions that they feel it's important for the court to know about. So they'll submit a friend to the court brief. And then opinions are when the judges and justices outline their rulings, opinions, reasoning around a decision that is put forward. So today what we'll be reading is an opinion, right? And you can have dissenting, concurring, and majority opinions. There is also, when the court disagrees, you may have a plurality, but that's more complicated, Pisco tells me. So mainly you're going to have the majority opinion, which one justice from the team of justices that agreed to go one way with a court decision will put forward. And that majority opinion is going to be the law of the land that other courts are meant to follow. Then there will be concurring opinions, which is justices that agree with the majority opinion, but have some things they'd like to say about it. And this is written by individual justices. And then you have a dissenting opinion, which is the justices that disagree with the majority opinion, outlining why they disagree with it. Now, these dissenting and concurring opinions can be referenced by other courts or other legislators or really anybody in the country, but they aren't the law of the land in the same way the majority opinion would be. So, for instance, Justice Kavanaugh on this case has a concurring opinion, meaning he agrees with the majority, but he has his own opinions that maybe some courts in the future will reference, like talking about Missouri. He doesn't think that states should have the right to enforce laws about abortion beyond the boundaries of their state. So if a state like Missouri wants to go ahead and try and prosecute or criminalize abortions outside of their state, maybe Kavanaugh disagrees with that. And if a court in the future hears a case about that, whether it's a district court or or, a circuit court, they could reference that opinion as well, although it isn't the law of the land. So they could say, hey, Justin Kavanaugh suggested that just because the ruling goes this way does not mean that the state has the right to enforce it beyond the boundaries of their state. And for that reason, we think that it should be X, Y, and Z. Also, some things to keep in mind, and I'll talk about briefly, are trigger laws. So 13 states, which would be Kentucky, Louisiana, and South Dakota, they're going to immediately enact laws based on this ruling. So Kentucky, Louisiana, and South Dakota are going to immediately put laws in place after this decision has been reached. So that's done. Then you have Idaho, Texas, and Tennessee that within 30 days, they will put laws on the books or enact laws or begin enforcing laws that kind of hinged on the decision here. Lastly, you have North Dakota, Wyoming, Utah, Missouri, Oklahoma, Arkansas, and Mississippi that say we will soon implement laws. That could be in a matter of days. Like with Missouri, they've basically immediately enacted some laws that have hinged on this decision. Or it could mean that in a matter of weeks or months, they will make some changes to the laws that will be enacted based on this case going through the way that it's gone through. 26 states that include Montana, Arizona, Nebraska, Iowa, Wisconsin, Michigan, Indiana, Ohio, West Virginia, Alabama, Georgia, South Carolina, and Florida all have laws on the books that are old that could kick into effect and start being enforced based on the ruling that has just happened. Missouri specifically would impact out-of-state abortions as well, though like we've said numerous times in the beginning of this stream, Kavanaugh does not believe that making it illegal across state borders is necessarily constitutional, even given the ruling that the Supreme Court has put down here. So, if you live in any of those states or you have interest in any of those states, there's a list of, the situations for those different ones and what to be aware of. So to talk about Obergefell v. Hodges, which happened in 2015, I'll give you a bit of a TLDR on it and then we'll go in depth about it. So basically what happened is a couple that by the time one of them had become deceased, had been together about 21 years, they decided that they wanted to get married. They were a same-sex couple, however. And in the state of Ohio, it was illegal for same-sex couples to get married. So before John had died because he had contracted ALS and, he knew he was on the way out, they went to Maryland to get married. When John had died, Obergefell, who is the person named in the case, wanted to be listed as John's surviving spouse. This was denied by Ohio. They denied him the right to the property of his spouse and other things that is generally granted to a surviving spouse. And so Obergefell and 13 others appealed and won in the district courts, which, mind you, is where the trial is held, right? And then they did 4 separate appeals that all went in their favor in the appellate courts and the circuit courts, but when they got an appeal in the 6th Circuit Court, they lost. The right to marry is guaranteed to same-sex couples through the Due Process Clause and Equal Protection Clause of the 14th Amendment. That was the conclusion reached in this case. It was a 5-4 ruling, so it was kind of divided even at a time where maybe liberal justices or, progressive justices held a lot of sway in the court. And same-sex marriage at the time had already been established in 36 states plus DC and Guam. So, things were already heading in that direction, even though, that the problems regarding same-sex marriage had gone back all the way to the 70s. And we'll talk about that a little bit. So there's a TLDR. Again, they won appeals in the 4th, 7th, 9th, and 10th on the basis that state-level bans on same-sex marriages is unconstitutional. In the 6th, they appealed to Baker v. Nelson that this was constitutional for Ohio to do, and many other cases reference this as well, though SCOTUS never used it in their opinions. let's go ahead and talk a little bit about that, because references to Baker v. Nelson are actually like really, really important when we're talking about same-sex marriage. So in Baker v. Nelson, which happened in 1971, again, we'll go all the way back to the 70s when we're talking about same-sex marriage, the Minnesota Supreme Court said it does not offend the Constitution to restrict marriages to opposite sex. The SCOTUS in 1972 dismissed the appeal without hearing it, resulting in the case becoming precedent. They dismissed it with one sentence. What they said was, the appeal is dismissed for want of a substantial federal question. In 2013, Minnesota ended up legalizing same-sex marriage, which should have kind of gone against that previous decision. During the appeal in the Minnesota Supreme Court, one justice turned his back during the argument, and none of them asked questions of either party during the oral argument stage. They referenced gendered language and the common usage of marriage, and that procreation and child rearing were central to the constitutional protection given to marriage. Quote, in common sense and in a constitutional sense, there is a clear distinction between a marital restriction based merely upon race and one based upon the fundamental difference in sex. This is because in part of the argument that they made, they said, hey, look, interracial couples, we've ended up ruling in one direction for them and protecting them. Those same protections should be paralleled in the defense of same-sex marriage. The Supreme Court was against incorporation, or the Court of Minnesota was against incorporation. There's that word, or the application of the Bill of Rights and amendments to the states, specifically the right to marital privacy derived from the Ninth Circuit Court in Loving versus Virginia in 1967, which was that handling the topic of the bans on interracial marriage. So that Baker v. Nelson case in 1971 was referenced by that Sixth Circuit appellate court when they were talking about this particular case. In the Supreme Court's opinion, so now shifting back onto that original case we were talking about, Justice Kennedy, who was very, very important because he was the swing vote in deciding this. He was that fifth vote that threw them over to a majority opinion. He stated in his decision that, quote, the court now holds that same-sex couples may exercise the fundamental right to marry. No longer may this liberty be denied to them. Baker v. Nelson must be, and now is, overruled, and the state laws challenged by petitioners in these cases are now held invalid to the extent they exclude same-sex couples from civil marriage and on the same terms and conditions as opposite-sex couples. He appealed to the 14th Amendment and said that this was a fundamental right. His four principles and traditions, which again, if you remember from that originalist interpretation of the Constitution, would be important to talk about. And what I see missing in some of the discussion in my research about this same-sex marriage thing is talking about the principles and traditions which Kennedy had used to justify his vote in favor of the majority. So he had four principles and traditions that he said proved that he should rule in this direction. He said, number one, the right to choose whether and whom to marry is inherent in individual autonomy. Number two, he said the right to marry protects the intimate relationship between two people. Number three, this right protects children and families to home build and rear children. And number four, marriage is the keystone of social order and foundation of the family unit. He says, quote, no union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. In forming a marital union, two people become something greater than they once were. As some of the petitioners in these cases demonstrate, marriage embodies a love that may endure even past death. Because remember, again, Obergefell was a spouse of John, and when John died, those rights that would be afforded to a living spouse were not given to him, and that was kind of the basis for their case. Furthermore, he stated the Equal Protection Clause entitled same-sex couples the same state benefits that opposite couples got. So that Equal Protection Clause, that discrimination against same-sex couples, they're not being afforded the same rights, the same benefits, the same privileges that a heterosexual couple would have. Alito, who, remember, is an originalist, Scalia and Thomas dissented, with Alito stating that the Due Process Clause only protects rights that are, quote, deeply rooted in this nation's history and tradition, which would not cover same-sex marriage. Alito believes this because of his originalist beliefs, hence they appealed to history and tradition being the only way to expand upon the meaning in that Due Process Clause. Furthermore, Alito was concerned that those who disagree, quote, will risk being labeled as bigots and treated as such by governments, employers, and schools, leading to, quote, bitter and lasting wounds, stating further that, quote, most Americans, understandably, will cheer or lament today's decision because of their views on the issue of same-sex marriage, but all Americans, whatever their thinking on that issue, should worry about what the majority's claim of power portends. Thomas believed the Due Process Clause should only apply to those being denied life, liberty, or property, and grants only procedural rights. So that means that when you're going through the justice system, there are certain rights that are afforded to you, certain procedural rights, and that's what the Due Process Clause is meant to be about. It's not meant to be about the same-sex marriage issue. It's meant to be about when you're depriving someone of life, liberty, or property, what is that process that you go through and what are the rights afforded to you during that process? It does not provide a basis for creating new substantive rights. Scalia agreed and worried that this stretched the reading of the Constitution and was, quote, a threat to democracy, robbing the states of the right to define marriage themselves. Roberts said that the Constitution doesn't define marriage, leaving it to the states, which now could not define/redefine it through the democratic process. He also warned the same logic could justify polygamous relationships. So one central theme that we're seeing here through all the dissenting opinions, and one that we're bound to see when we begin to go through the opinion that we'll read today, is this idea of the states need to be able to legislate this, that this isn't something that we could derive by squinting super hard and looking at the amendments or rights in the Constitution and then expanding well beyond what the text says or maybe even what the Founding Fathers had intended about those amendments or about the Constitution. That by expanding this, by taking the decision away from the states, we're doing an injustice to the American people. And we're going to further kind of create a divide in the country by these unelected people in the court making decisions that really should be made by the representatives of people in the states. And that if we keep doing this, we're going to keep doing that on plenty of issues and create more division in the country. And I think regardless of what side of the issue you stand on, this isn't an unfounded worry. We see that after cases like this, whether it's Roe v. Wade or Obergefell, we're seeing that there's a lot of division created around this. And there's no way for people that disagree to really, move against those decisions, because again, the Supreme Court is the law of the land. And if they're making decisions that kind of take the ability to make those decisions out of the hands of the states, then they're left with no choice but to try and do something with the court to get officials on who they agree with or who are philosophically in line with their ideals, and then to overrule a lot of these cases in the past, which we're seeing now and probably will continue to see with more decisions that the current court makeup is going to rule on. So I really do think that regardless of where you stand on the issue, that happened. They were right. There was a lot of division in the country. People were treated as bigots and people were treated poorly because they disagreed with what the Supreme Court decided. And the conservatives in this country have moved to try and get their Supreme Court justices on that are in line with their beliefs, and they've been working at that for a long time now, and they've been successful in it, and they will likely continue to see success in that strategy as the court rules on more decisions and likely overturns other things that have been decided upon in the past. So, I think that it's important, and I hope that this channel encourages people to you have to be willing to agree with people that you disagree with on other things. So People are right and wrong about many, many different things. You may think that same-sex marriages is a right that should be afforded to everybody. You may agree with the decision in that case. You may disagree with the people who had dissenting opinions about it, but they were right in some regards. And I think it's important, and something I try to encourage on the channel. We need to kind of divorce our emotional relationship to the people and the arguments that we see, and try and hear people out. At the end of hearing them out, you may disagree with them on a lot of the stuff that your emotions told you were going to disagree with them about, but it doesn't mean that there isn't truth listed in there. And I think that that's also something that we're probably going to see with this opinion. The people who disagree with the court's decision are going to be divided from and looked with angst upon by the people who agreed with the court's decision today, in much the same way that they were when Roe v. Wade was initially passed, or when Casey v. Planned Parenthood kind of expanded on that decision, right? Or in Obergefell, if you were somebody that disagreed with gay marriage, you were probably treated as a bigot, and the court and the society is going one way and you're being left behind in the other way. And now the Supreme Court has decided this way, you're likely going to be divided from the rest of the people, and division is a major problem in the country. That's why I mentioned at the beginning that my personal opinion is that you have to leave these things up to the states. And in my opinion, it's much, much easier for you to try and get the rights afforded to people in each individual state. You can't go outside of Justice Kavanaugh's home and threaten his life or the life of his family and get him to rule one way. When you put all of these decisions in the hands of 9 unelected people, that's going to be a far more difficult situation for the average person to influence than influencing their state government through hearings, through voting, through the selection of candidates that they agree with, through propositions, right? I think that the average person has much more control over things happening within the boundaries of their states through the legislative process than they would over what the Supreme Court decides. And I think it could be far more frustrating for people to have to deal with a decision by the Supreme Court that they disagree with than one that has been decided by their state legislature. And you may imagine that both of those scenarios are very difficult, and I don't think you're wrong to think that. But I think you would be wrong to think that you have more impact over individual Supreme Court justices and influencing the decisions of the Supreme Court than you would over influencing what your legislator decides and what is happening within the bounds of your state. And for that reason, I think you have more power as an individual person if this is left up to the states. And that goes both ways, unfortunately or fortunately, depending on where you live and what side of the aisle they're falling on. But I think that there are nuggets of truth in decisions that I would otherwise disagree with from some of the conservative justices here. So that's important to keep in mind. That's kind of a TLDR and a little introduction on Obergefell v. Hodges. Again, that's a case in 2015. If you enjoyed that, definitely let me know in the comments down below. I would be happy to do more of these. We have prep for a lot of different court cases, and I would be happy to go the extra mile and prep those for a stream if that's something that you guys are interested in. Yeah, I wanted to try something new at the beginning of the stream with that. So definitely let me know how you felt about that, because we don't often do something like that. I don't know.